Good morning, everybody. Welcome to Get Real with Cristen Martinez. Today, our topic is evictions and COVID-19. While there is going to be a presentation on this topic, it will be very short. Please note that this is an informal roundtable, and we welcome questions not only on the topic that we're discussing today, but on any other topics that you may have. Again, thank you so much for being patient and letting us get through those technical difficulties. If you experience any technical difficulties on your end, we find that sometimes stopping your video can help with those issues. I'm going to go ahead and introduce myself. My name is Stephanie Gibson. I am the COO at Martinez Law. I've been with the firm for about 2.5 years. My background is in accounting, but since coming on board here, I have been able to get my hands in a little bit of everything, including some contract work, helping out with some paralegal style work, plus, all the management of the day-to-day operations of the firm.
Looked at the participant list. I think I know everybody. If I don't know you, my name is Cristen Martinez Weiner. I own Martinez Law. We are a real estate law firm handling real estate litigation as well as transactional matters. We've been open since 2015. We're in our 6th year, and we are very excited to be hosting these every single month. The purpose is to get your questions answered, educate you, find out what issues you are seeing in your day-to-day life as a real estate professional, and try to help you through those issues, and try to keep you from having to call my office with a dispute or a litigation matter. That is always the goal, is to avoid those types of calls. So today we're going to be talking about a very hot topic. One of the most common questions I'm getting currently in my office right now is with regard to evictions and how the COVID-19 moratorium is affecting evictions. What can I do if my tenant is not paying? If my tenant has breached the lease by, having an unauthorized pet or an unauthorized occupant in the premises? What are my options, basically? And the answer is very, very complicated. This is all new to everybody. So, while I think the intent behind this moratorium is a very good one, I think the implementation of it has been problematic. So I may not have clear-cut black and white answers for you, but I will give you kind of the lay of the land, the moratorium order we will go through, and touch on exactly what types of tenants and what types of evictions are subject to it, and then what advice we can give to landlords who are having issues with a tenant during this particular time. So the actual CDC order, it has now been extended through March 31st of this year. May be extended further than that. We don't know at this point, but as of right now, it is extended through March 31st. And it's a 13-page order, so it does have a lot of background. It goes through its specific objectives, and it is very specific as far as what types of tenants and what types of evictions are subject to this moratorium. I think most people are under the impression that no evictions can proceed, no matter who the tenant is, no matter what the basis for the eviction is. And that's not true. So the beginning of the order starts out with some definitions, and one of the most important definitions is the definition of a covered person. Basically, that means, who does this apply to? What types of tenants does this order apply to? And I'm gonna read from this just to make sure that I'm giving you the most accurate information. So there's 5 different criteria that a tenant must meet in order to be able to avoid an eviction under this moratorium order. The first criteria is that this tenant has used his or her best efforts to obtain all government assistance for rent or housing. So a tenant should have to show that they have applied for government assistance to help them with their rent payment. If they've been denied, that's okay. They just have to show that they've applied for and have made an effort to obtain that assistance. The second requirement is that the tenant earns or expects to earn less than $99,000 in the calendar year for 2021, or they have received the economic impact payment stimulus check. So if they fall under either one of those 2 categories, they satisfy requirement number 2. The third requirement is that the tenant must be unable to pay the full rent at the time that it is due as a result of loss of household income, loss of working hours or reduced wages, a layoff, or extraordinary out-of-pocket medical expenses. And the definition of an extraordinary medical expense is a medical expense exceeding 7.5% of one's adjusted gross income for the year. So this is a big one because I see a lot of tenants that can afford to pay rent or they can afford to pay partial rent. They're just not. They're attempting to take advantage of this order and, say, well, I can live for free and I can't be evicted, so that's what I'm going to do. That's not what this order provides for. You have to be able to show through either a loss of a job, a reduction in wages, a reduction in hours, or an extraordinary medical expense that you cannot make the full rent payment on time every month. The fourth criteria that a tenant must meet is that they are making their best efforts to make timely partial payments that are as close to the full payment as the circumstances may permit. So again, this kind of ties into the third requirement, but they have to be making a good faith effort to pay their rent. So if their rent is $1,000 a month and they can only afford to pay $600 a month, they have to pay that $600 a month, or they cannot take advantage of or utilize this eviction moratorium. The fifth and final criteria is that a tenant would have to show that if they were evicted, that it would render them homeless or it would cause them to have to go into a shared living setting. One of the primary objectives of this moratorium is not to help out people who have had a loss of income or a reduction in income. It is to help stop or slow the spread of COVID-19. So the thought behind it is if we have an increased homeless population, or if we have people having to leave their rental to go live with, in a group home or live with other family members in larger groups, that's going to contribute to the spread of COVID. And that's one of the objectives of this order. So the final requirement is that they would have to show that they would either be rendered homeless or have to go live in a group or shared living setting if they were evicted. These 5 requirements are pretty steep. I would argue that there are very few tenants out there that meet all of these 5 requirements. We'll kind of talk about how the order is being implemented in reality versus what the objectives and the intent behind it is. But these are the 5 requirements that must be shown in order for the eviction moratorium to apply. If a tenant, can show 4 out of the 5, they can still be evicted. This order, in theory, doesn't apply to them.
Hey, Cristen, if you can hear me, you're breaking up.
That, we would have to go live with other family members or relatives out of state. That would be a good basis for this to apply. All right. A couple of other provisions that I want to point out in the order before we kind of talk practicality of implementing this thing is, revolves around a lot of questions that I get. So one of them is that it specifically states in here that the order does not relieve any individual of any obligation to pay rent or comply with any provision of their lease. So even if this moratorium applies to you, or you have a tenant that meets all 5 of those requirements, they're still obligated to pay rent, to pay late fees, to pay interest on rent that is not paid on time. So what that means is once that moratorium is lifted, let's call that April 1st, all rent payments that were either missed or that were not made in full become due at that point. So even if this order applies to a particular tenant, it would still be advisable for that tenant to pay what they can, because at the end of the day, it's all going to become due at a lump sum once this moratorium ends. It also states in here specifically, nothing in this order precludes the charging or collecting of fees, penalties, or interest as the result of failure to pay rent on a timely basis. So the order does not alter any terms of a lease agreement between a landlord and a tenant. It merely provides basically a freeze or a hold on the ability of a landlord to evict a tenant that complies with those 5 requirements. So let's talk about some of the issues that I see in practice with this order. And I'll just preface this by saying that the way the order is written, I think it's great. I think there are tenants out there that need the help. I think that these restrictions and this requirements kind of weed out those tenants that don't need the assistance from those who do. So applied and implemented the way it's intended to, I think it's a wonderful thing. In practice, however, I'm not seeing that. I'm seeing a very sporadic, non-uniform implementation of this order between counties and also between judges within the same county. This has resulted in a lot of confusion, a lot of delays, a lot of frustrated landlords, and it has enabled a lot of tenants who don't need the assistance or who don't comply with the 5 requirements that we spoke about to continue to live in their rental unit without paying rent for, we're coming up on almost a year now, come April. So I do think there are some unintended consequences that have resulted from the non-uniform, for lack of a better term, implementation of this order. Personally, I have seen judges handle this thing in many different ways. What is required is the tenant is required to fill out a CDC declaration that recites those 5 requirements that we spoke about and sign under oath that they meet those 5 requirements. Many tenants sign that, they file that with the court in response to their eviction claim, but none of those things are actually true, or none of them have been proven with documents or any other evidence. So, for example, I have a case where we know the tenant doesn't comply with several of the 5 requirements, including the fact that they make more than $99,000 a year. However, we filed for eviction, they signed this declaration and filed it. Within an hour of them filing this declaration, the judge has stayed my case. I don't get a hearing. I don't get a chance to challenge the fact that they do not meet these requirements. I don't get to require them to come and prove that they actually meet these requirements. The fact that they've signed the document and filed it is enough for this particular judge to continue to stay the case without looking any further into it. My landlords now are being faced with having to default on their mortgage and facing a potential foreclosure because they haven't received rent in almost a year from tenants that have the ability to pay, or at least have the ability to pay partial rent. So that's one example. I'm seeing that a lot. There is a lot of confusion in the enforceability of the order and how it's implemented and who it applies to, despite the fact that it is very, very specific. So those are some issues we're seeing. Of course, this is causing delays and a clog in the court system. The delays are going to be even greater when this moratorium is finally lifted because all of these evictions that have been stayed or put on hold will now be fair game and will be able to move forward all at the same time. So there's going to be a huge backlog of cases on the plates of these judges handling evictions in the various counties. So that's something we're going to have to deal with as well. So let's talk about some things that landlords can do. Like I said in the beginning, I'm not going to have black and white advice that is going to work in every situation because we're dealing with judges who are human beings who have their own personal biases and ideas and the way they do things, and that is beyond our control. So one thing that I will recommend first off is before signing any new lease with a tenant, before deciding to rent your home or an investment property to a tenant, before renewing a tenant for a new term, make sure that you have really, really solid leases because this moratorium only applies to evictions for non-payment of rent. So you want to make sure that you have a lease that specifies all of the other rules and regulations that you want the tenant to abide by, because if they violate one of those, you can absolutely evict on those. If you are on a verbal month-to-month lease, none of that would apply. If you are, using a form lease that you found on Google, there's probably going to be a lot of holes and a lot of important provisions missing from something like that. So before you enter into a new lease or before you renew a lease, make sure that you have that lease either drafted or at least reviewed by an attorney to make sure that you are covering yourself as best as possible. The next thing that I would recommend is the order only prohibits the actual eviction of the tenant. It does not prohibit the filing of an eviction lawsuit. It does not prohibit you from going through the entire eviction process. The only thing it prohibits is that very last step. After you get a final judgment for eviction, you're issued a writ of possession, which the sheriff goes out and serves on the tenant and makes the tenants leave the premises. The service of that writ of possession is the only piece that this CDC order prohibits from happening right now. So as a landlord, what you can do is you can go ahead and file the eviction, get all of your evidence, get your final judgment, get the writ of possession, have it waiting at the sheriff's office so that the minute that this moratorium is lifted, all that has to be done is the physical service of that writ. You don't have to wait in line and go through the entire litigation process. You'll be set up and ready to go. So I have that set up with many of my clients. I call the sheriff every month when this moratorium is extended and say, hey, we're holding off on another month, but I just want to make sure you still have my writ and we're still set to go when this thing ends. And that's all set up for us to be ready come April 1st or beyond. And then the final thing I'll say is that since this moratorium has been in place for so long, we are now coming up on the expiration of a lot of these leases. The lease term is ending. Most residential leases are going to be for a term of 1 year. Because we're into this thing almost a year, those terms are coming to an end. So what that means is that even if your tenant is behind in rent, if the lease has expired, the landlord can go ahead and evict on the basis of the expiration of the lease, which is not covered by this moratorium. So that is an option. I've actually amended some of my previous eviction actions that were filed for non-payment of rent. We've now amended them to include a separate count for eviction for expiration of the lease, which is not prohibited by the moratorium, and we can push those through. So it's not an ideal situation for anyone. However, there are some things you can do as a tenant to protect yourself. You do need to get representation and make sure that you are filing the proper declaration with the court. If you comply and you fall under those 5 requirements that we went through. And there are also some things as a landlord that you can do to not make the situation perfect, but make it better and set yourself up so that when this moratorium is lifted, you are prepared and ready to get your tenants out and get new paying tenants in as soon as possible. So I think I went over my time a little bit on this, but I will go ahead and open it up for questions. I think in the chat, we have a couple of questions here. Sam asked, which county and which judge? It is Hillsborough County, and I'm drawing a blank on the judge's name, but I can get that for you. And unfortunately, the way our court system works is you have no control over which judge gets assigned to your case. It's just a random luck of the draw type of thing. So let me pull this up. Order. Okay, so the judge I referred to is Judge Hernandez. He's a fairly new judge. I don't know if he just got elected or if he's not quite that new, but I have him on several eviction cases, and he is signing these orders electronically, staying the cases without any opportunity for a response or a hearing or anything like that. And given his previous orders, I don't know that it is worth me pushing for a hearing, because I think that regardless of what I present, he's going to automatically stay all of his evictions for non-payment of rent anyway. So the case that I mentioned, we're actually amending, or we have amended the lawsuit to move forward on eviction under expiration of the lease, because the lease is now expired. So follow-up question to that, do we need to add COVID language to new leases? That is not a bad idea. So language that you can add to your leases should or could include things going forward that relate to these 5 requirements that tenants have to show. So you could either do this in your application process for tenants or directly in the lease. But for example, you should be able to verify employment and income. If they apply and they report income of more than the $99,000 a year, that's something that come time to evict, if that situation arises, you know that that's not a requirement that they would fall under. Some of the other ones are going to be hard to put kind of preemptive language in, like I've done everything I can to apply for government assistance. I've done everything I can to make partial payments. We cannot put a provision in the lease that no matter what happens, you can evict me and the moratorium doesn't apply to me. That is language that we cannot put in a lease, or we could, I just don't think it would be enforceable. Let's see, is the $99,000 household income or individual? It is individual. So each adult on the lease has to separately meet all 5 of these requirements, and they have to file their own separate declaration that they have met all of those requirements. So that would be on an individual basis. All right, let me see.
Cristen, there were a couple of questions above that last one. So one was from, I hope I'm pronouncing your name correctly, Rena. It says the lease handed and the tenant has been month to month since. So the order would apply in this case, question.
The order would not apply because the lease has ended and you're now on a month to month. The basis for the eviction would be that the lease has ended. It would not be for non-payment of rent. So this moratorium would not apply in that instance. You would have to give a 15-day notice. Hey, your lease has ended. You need to be out in 15 days. If they're not out in 15 days, at that point, we could file the eviction and that would go through despite this moratorium.
Okay, and then Mary asked, in the standard Florida Realtor lease, does it provide eviction for the end of lease or eviction for other reasons?
So eviction can be based on either non-payment of rent, it can be based on any other violation of the lease, or it can be based on the fact that there is no lease. Either there was never a lease or the lease term ended or expired. So the contract doesn't say you can evict for all of these reasons, but it says you're not allowed to keep pets. You are only allowed to have these listed occupants. You have to comply with the applicable homeowners association rules. You have to keep the property maintained in a clean and neat state. All of those items, if not complied with, could be a basis for eviction, in addition to the lease term expiring. If that didn't answer your question, shoot me a follow-up question, but hopefully that did.
Yeah, and just to reiterate, you're welcome to use the chat if that's what you prefer, but you can also unmute yourself and ask the question to Cristen directly.
I'd like to follow up on one of the questions in regards to the caseload. One of the concerns that I have is in April or May, when this whole thing starts to unravel, I mean, are we going to have a deluge of properties that are going to become vacant and a ton of people that are going to become homeless? You know, and I'm just kind of wondering if that's going to precipitate some other issues moving forward. So can you comment on the number of cases that these courts are currently seeing? Any idea there?
Am I back? No.
I can hear you now, Cristen.
Am I back? All right. Sorry, guys. I don't know what's going on with my connection issues here. Okay, I missed the whole last part of the conversation or the last question. So
the question that I had was in regards to current caseload when it comes to evictions. Do we know roughly how many eviction cases are moving forward? Because I'm just trying to anticipate what the second half of the year is going to look like in the way of, you know, vacancies and, you know, upcoming listings and that kind of stuff. What are we looking at here? I mean, how much of this is actually on the books?
I don't have numbers for you as far as current volume or caseload and what that's going to look like. I can tell you from personal experience and from talking with other lawyers and other judges, it's going to be a huge volume of evictions and foreclosures, because foreclosures are also halted right now, that are going to be filed as soon as this thing is lifted. So in my office, I would say about 20% of my evictions are actually moving forward and going through right now. So that means 80% of them are just on hold and there's nothing I can do. So I don't know if that's everybody's experience, but I would assume that at least more than half of evictions are just on standby right now. So I do think it's going to create a ton of vacancies for both rentals and due to foreclosures. All right, so I think
one last question. Does any of the eviction moratorium apply to commercial tenants, or is it strictly residential?
Strictly residential. There is no moratorium or any sort of restrictions on commercial evictions right now. Although I do have commercial tenants that filed this declaration, but it doesn't apply to them. Okay.
So, Cristen, we got another question from Mary. It says, would you recommend to add an addendum to standard Florida realtor lease to increase eviction reasons?
No, I don't think something like that is necessary. I don't think it's incorrect to do that. I just don't think it's necessary, because you can evict for any violation of the lease. So in order to be able to evict, you don't have to have a separate clause stating that I'm allowed to evict if you don't follow the rules. I'm allowed to evict if you don't maintain your lawn. I'm allowed to evict if you damage my property. That's all incorporated in the lease and in the Florida statutes. So a separate addendum or separate language like that really wouldn't be necessary. It would just be more redundant.
Okay, and then we have a question from Betsy. It says the standard Florida realtor lease is pretty legit, correct, Cristen? I have had a judge here actually prefer it. What are your thoughts?
So my thoughts generally on standard form contracts are that they are standard form contracts and they cannot possibly cover or address every issue. Also, because they are standard form contracts, they are drafted very equally to both sides. So they're not more in favor of the landlord, they're not more in favor of the tenant. They're drafted pretty much even keel to both sides. Now, in Florida, our laws are a little bit more landlord friendly than tenant friendly. So I still think there's a little bit of a skew toward landlords. However, if I'm representing a client, I will not use or recommend a standard contract, because I think they can be better protected with a contract drafted with their interests in mind. So a standard contract isn't necessarily bad, but I just think it doesn't cover and provide as many protections as I think you could otherwise get. Also, if there are, unique circumstances or something about this particular property that, maybe there's a saltwater pool or something that requires a certain type of care or maintenance that is not going to be covered by something standard. Things like that you'd want to include, but the biggest thing is you want to make sure your client is protected as possible, and a standard contract is just not going to do that.
And then Cristen, she had a follow-up. It says, if there was never a lease, they are not protected, correct?
Correct. If there was never a lease, they're a month-to-month tenant, which means that you can give them 15 days notice to get out at any time. If they don't get out within 15 days, you can evict at that time. All right. Did we hit all the questions in the chat?
I believe we have gotten everything in the chat.
Okay. All right, what other questions do you guys have for me? I know there's a lot out there based on the calls that I get.
So at this point, moving forward, it sounds like we should all be having all these leases looked at this point or revised. either with specific language for COVID or addressing the CDC rules. Do you see any changes in the CDC rules? Have you seen any adjustments moving, because this isn't the first time that they've extended this moratorium. Have there been changes? Has this been evolving? Or, I'm just trying to forward think this thing.
It has been evolving. So this current order just came out in the beginning of January. So it is effective January through March 31st of this year. And it is much more specific than previous orders, which tells me that they don't want tenants taking advantage of this. They don't want, landlords being stuck with a mortgage that they can't pay because, they're not receiving their rent. They have really specified and nailed down the requirements that a tenant must meet in order for this to apply and protect them. So that is part of the evolution that I've seen in these orders. I don't know if it's going to continue to evolve or if they're just going to continue to extend this one, or maybe they're not going to extend it. But it used to be, you can't evict for non-payment of rent. Then it was, you can file the eviction and go through the process. You just can't finalize the eviction if it's for non-payment of rent. Now it's all of that, plus we have these very specific criteria and requirements that a tenant has to make and prove up.
I see. Now, in regards to the foreclosure part of this, is the foreclosure applicable to investment properties as well as your primary residence? Is the moratorium applicable to that?
The eviction moratorium?
No, the foreclosure moratorium.
Yes. So that's reserved only for residential, but it doesn't matter whether it's primary residence or investment property.
I see. Okay.
Same with the eviction moratorium. It's all residential, so it doesn't matter. What
I'm just thinking if you're a landlord that's got 10 properties and those properties are not performing, now you're going to have 10 potential foreclosures hitting the market right at the same time all these evictions are going down. That's
yes.
Okay, I gotcha.
And I see the foreclosure issue being dragged out a lot longer than the eviction issue. So what I mean by that is once this thing is lifted, evictions are going to be filed immediately. They are typically handled by firms, either big firms or small firms, but they're not handled by kind of like volume-based firms. So sometimes I call volume-based foreclosure firms foreclosure mills. All they do is churn foreclosures and every attorney has 80 files on their desk. Evictions typically aren't handled by those types of firms. So I think they're going to be filed much more quickly. And I also think it's much more urgent for a landlord to get a tenant out than it is for a bank to foreclose. Also with foreclosures, the banks are going to be overloaded and their attorneys are going to be overloaded. So those typically proceed a lot more slowly and drag out a lot longer anyway. So I don't see, thousands of foreclosures being filed right away. I think that's going to drag out and take years to kind of sift through all of that just because of, the volume and
but they're coming
types of firms and the banks and how they operate.
I see. Okay. Thank you very much, Cristen. I really appreciate all the.
Absolutely.
Hey, Cristen. Oh, sorry.
Okay.
Sorry. Okay, so basically with these 5 must meet, you're saying that some judges are just like not even paying attention to those must meets, right? So then it just depends on the county, the judge, et cetera. That's what you're saying. So what happens, I'm always thinking like worst case scenario, but what happens if March 31st comes and they extend it again till September or something? Like what happens to these homeowners, that have loans, on these homes and they can't pay for it? What happens to them? I guess I'm more concerned about the homeowner than the tenant in a sense,
So, the unfortunate thing is they really are left unprotected. What happens probably is they default on their mortgage. They can't be foreclosed upon until this ends. But just like with the rent that continues to come due, whether you're paying it or not, your mortgage payments continue to come due even during this moratorium. So let's say it's lifted September 1. You may have 8 months worth of mortgage payments that are all now due on September 1. And most people can't make that payment. So they're either going to be facing a foreclosure, or they may have to look at, you know, refinance options, short sale options, deed in lieu options. Maybe they can get a loan modification. All of those things, you know, they'd have to qualify for, but those are all options I think the banks are going to have to consider.
You froze again. You froze again.
Oh no, am I back?
You're back.
Okay, sorry
I'm
guys.
just happy that it's not me, because I'm over here in Dade City, and usually I have my
I did this yesterday and I had 0 issues, and now today it keeps freezing up in the exact same spot.
Got it. You know, I appreciate all this. I just, you know, it just is crazy to me that, you know, that these standards are set in place, but judges are not using them, you know? You know, I mean, these are really good standards that are set in place, but if the judge is not even making the tenant accountable for these standards, you know, that's like, it's crazy, you know? And there's nothing you can, like you said, there's nothing you can do. Can you like request a new judge?
So here's that.
Can you fire the judge?
The answer is yes. You can ask for a judge to recuse him or herself. However, you have to have really good basis to do that. So you have to show bias or something like that, which is very hard to show. And if you lose and your motion for the judge to recuse themselves is not granted, you're in the doghouse with that judge. So unless you really have a slam dunk case for getting that judge off of the case, you know, the judge has a relationship with the other party or something like that, it's not worth taking that risk, because chances are you're going to lose, and then the judge is not going to be thrilled with you moving forward.
Yeah, it's going to be even worse moving forward.
Exactly. So,
okay. Thank you. I appreciate it.
You're welcome.
Okay, excuse me, Kristen, we have some questions from Debbie.
Okay.
The question is, does the tenant have the right to stay if you accept their payment, even if they are month to month?
If a tenant is month to month, they have a right to be there unless and until you give them a 15-day notice. And that notice will state that your month to month tenancy is over. I'm terminating it. You have 15 days to be out. If they're not out within the 15 days and you continue to accept rent, that's okay. You can still evict them. Hopefully that answers your question, but accepting rent does not waive your right to evict them.
We apologize again, everyone, for the technical difficulties.
No. Sorry, guys.
Okay, you're back.
How many times is this going to happen before we're done for the day? All right. Did I miss any questions? Let me see.
So Debbie had another question. It says, if you have a 10-unit building, does it fall under the CDC guide?
I don't know what to do.
Kristen, can you hear me?
Yeah, does that help if my video's off?
It might help. It might help if your video's off.
Okay, I know that's not ideal, but we'll try it this way so at least you guys can hear me. So if you have a 10-unit building, does the CDC guidelines apply? Is that the question?
Yes.
Yes, because those are still residential leases. So every single tenant in each one of those units would have to show that they meet the requirements. And if they do, then the CDC moratorium would apply.
Okay, and this is just a general question. I've had a number of people ask if there will be a recording of this video, and the answer to that is yes. We actually have a YouTube channel, and we will be posting the recording onto our YouTube channel. It will probably be up by the end of this week. I put a link in the chat for everyone to see, but if you search Martinez Law, Florida Real Estate, you should be able to find our channel. And we hope that you guys will, subscribe to our channel as well.
All right. I tried my video again, so hopefully it will work.
So far, so good on your end, as long as you can hear me.
I can, yes.
Good. So we have about 15 more minutes before we need to wrap up today. So we welcome any other questions that you may have.
Kristen, how are you? It's Betsy.
Hey.
So I think that just something to share is I send a lot of my clients to Kristen to set up their LLCs prior to purchasing properties. So just something to share to the group. I know, like Robin, you were asking some questions about what these people can do. And if their, portfolios are set up more like businesses, then there's more options for them to, borrow money at a time like this, or, have some more options if they're actually set up correct. So I think that that's just really important. So I know that's kind of like off the COVID topic, Kristen, but I think it's important, for us realtors or commercial realtors or CCIMs, that as we're, helping people buy investment portfolios, we're going to get a lot of clients that, of course, are going to take advantage of the short sales and foreclosures and just kind of the market shift, that we're sending them to proper attorneys and CPAs to get them set up to put them in a proper position if something like this happens in the market.
Yep, and that's an awesome point, Betsy. I've said this a million times. I'm going to continue to say it, but you never, ever, ever, ever want to have a client who owns an investment property in their individual name, ever, under no circumstances. So it needs to be in an LLC. It needs to be in a trust. It needs to be in some sort of entity so that they are protected. And then, like Betsy said, that also opens up some additional opportunities in markets like this. But the biggest reason is to make sure that you're protected.
Because I've had some of them be able to qualify for like some SBA stuff, which, yes, there's a very small interest rate, but for a smaller owner that only owns, 2 single family houses that does have the LLCs, to get $50,000 or $60,000, that's a crutch for them while a tenant's not paying rent, actually ends up being a huge deal in a time like this,
Absolutely. Yes. Thank you for that.
We have time for one, maybe two more questions if anybody has any.
I just wanted to interject something that might be of benefit to everybody. And that is, when you're underwriting your tenants now, I mean, you have to look at, whether or not they are engaged in a business where they're going to either be laid off or their business is going to be closed down again. It's unfortunate that we have to look at things like that, but that's one of the new underwriting requirements that we have, is to look at, are you in an essential business? And, if you're not, or you got shut down before, I mean, you have to advise your clients to say, hey, you've got some potential risk here regarding their income and whether or not it's going to be viable and stable for the long haul. If we have another resurgence, or, the lockdowns are continuing on a perpetual basis, but just something for everybody to think about. I think this is going to be a long-term problem, unfortunately, from what I'm hearing.
Yeah, and I would add to that too is tenants who are self-employed are also going to be higher risk right now as well. My advice is not that you should not rent to a tenant who is self-employed, but you should take a closer look at how long have they been in business, what do they do, in revenue per year, before making that decision, because tenants can very easily alter their income when they're self-employed. And it also becomes an issue if you evict them and you also want to recover back rent or damages from them. If they're self-employed, it's very easy for them to hide those funds or disperse those funds elsewhere. And if your judgment is only against them personally, you can't get to those. So that's an awesome point. And then I would just add to that your self-employed tenants.
Hey, Kristen, I have a question for you. Can you hear me?
Yep.
Hi. My question is about, let's say that the moratorium is lifted and now you want to start showing the properties and the tenant is not cooperating. How can we, let's say that, you give them 24-hour notice, but they start making excuses as to how it cannot be shown. What do you advise?
So that is a provision in almost every lease that a tenant has to provide access upon reasonable notice. Reasonable notice is defined as 24-hour notice. So that would be a default of the lease, just like any other default. So if they're not cooperating and coordinating a date and time for landlord or their agent to get in and inspect the property or show the property, notice needs to be given to them. In this particular case, it would be a 7-day notice. So you'd have to notify them that your failure to allow access is a violation of your lease. You have 7 days to cure the violation. So you have 7 days to give us access. If you don't, we can evict you at that time. And if they don't provide access within the 7 days, you would have the ability to evict on that basis. And that would not be protected by the moratorium.
Oh, good. Thank you.
All right. Let's see. All right. Any other questions before we wrap up? All right. Well, if she hasn't already, Stephanie, if you want to just shoot my email address and our office number in the chat there, I think most of you have it, but in case you don't, if you think of any other questions or you need anything, feel free to reach out. I do not mind at all taking your questions and talking you through them. And then I think Stephanie's supposed to do this, but I'll go ahead and introduce our next Get Real is going to be in March. It's the first Wednesday of every month at 10:30. Our topic is going to be seller disclosure law. So right now, evictions are kind of the hot topic that I get asked about a lot. In a calmer, non-COVID market, one of the top issues that I get in my office from a litigation standpoint is seller disclosures. When is a seller required to disclose something? What particular defects have to be disclosed? What to do if a seller doesn't disclose something? So that's going to be our topic for March. Of course, come prepared with your questions. They don't have to be about that topic. Hopefully there's something real estate related, but they can be on any topic that you have or that you're curious about. Also, if you want to shoot me an email and suggest topics that you want me to present on or that you want me to talk a little bit more at length about, I'd love to hear those suggestions and implement those into our monthly Get Real events. So thank you so much for coming. Thank you for your patience. We will get these technical issues cleared up before next time. But thank you guys so much.
And to jump in real quick, I left the link for our Eventbrite registration for next month's Get Real. So you can use that link to register if you're interested. All right.
Thank you,
everyone.
Kristen.
Great. Thank you guys.
Thank you.